Good afternoon, everyone, and welcome to the webinar, Stop Calling It Revenge Porn, Prosecuting Image Exploitation. My name is Emily Thrush, and I'm the project coordinator at AEquitas, the Prosecutors Resource on Violence Against Women, and I will be moderating today's webinar. This presentation will explore the various forms of image exploitation and the types of statutes under which this abuse can be prosecuted, enabling prosecutors to choose the most advantageous charging strategies within their own jurisdictions. In addition, offender-focused trial strategies will be offered to assist in overcoming common victim-blaming defenses. Before we begin the substantive portion of our program, I will provide a few logistical notes. If you have technical difficulties, please contact ILINK directly at 1-800-799-4510. And if you're using the internet audio option, we recommend you dialing in with a phone since the connections are often more reliable. I have the conference line number in the public chat section in the event you are disconnected and don't have it visible on your computer elsewhere. Throughout the presentation, if you're unclear about anything, you can private chat me, which the chat option is on the left-hand side of your screen below the attendee list, and I will share your questions with our presenter so they can either be addressed during the webinar or followed up after the webinar is over. Today's webinar is hosted by AEquitas, the Prosecutors Resource on Violence Against Women, through funding from the U.S. Department of Justice Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and the presenter's biography, will be emailed to you after the presentation. In addition, we are recording today's webinar for later viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas staff conduct legal research, we provide 24/7 case consultation, host specialized or state-specific training events and webinars. We provide individual experts to jurisdictions and organizations, and publish resources on topics relevant to the prosecution of violence against women. The individualized assistance AEquitas provides is data-driven and incorporates customized strategies that are easy to implement, resulting in prosecutors' ability to sustain effective practices and promote systemic change. Today's presenter is Jane Anderson, attorney advisor here at AEquitas. Prior to joining AEquitas, Jane served as an assistant state attorney with Florida's 11th Judicial Circuit in Miami-Dade County. She spent her career handling domestic violence, sexual assault, homicide, and human trafficking cases. By helping build a coalition of service providers and community leaders, Jane was able to promote victim safety and provide the necessary support to help victims be able to participate in the criminal justice system. Most recently, Jane focused on building stronger prosecutions through the use of cyber investigations and digital evidence. Jane is based out of the San Francisco Bay Area. The full biography for Jane will be emailed to you following the webinar, along with today's PowerPoint slides, a PDF of them. And I would now like to turn the floor over to Jane for the substantive portion of our presentation.
Thank you so much, Emily, and good afternoon to everyone. I'm so glad there are so many people that are participating in today's webinar. And we are going to basically talk about image exploitation on a broader scale, and we'll identify all the different criminal statutes and crimes that may be implicated when we're looking at this course of criminal behavior that offenders engage in. So we'll talk about sort of strategic charging decisions and also strategies for overcoming some of the gaps that you may have in your own state statutory construction. We'll talk about that. And then ultimately, the broader idea of how do we overcome some of the public's, which includes our juries, our judges, our law enforcement, our prosecutors, our defense attorneys, everyone in the system, how overcome some of the preconceived ideas about image exploitation and maybe the minimization of harm and things like that. So that'll be how we'll go through today's webinar, and we'll start off with kind of talking about what is image exploitation. We at AEquitas decided to take a broader view of image exploitation sort of after we started seeing more attention being brought to things that the media likes to refer to as, you know, revenge porn or sexual exploitation, sexploitation, lots of creative names going on, and perhaps the power of the word can have both positive and negative impact. But in this case, we're going to take a broad look at what we're defining as image exploitation. So what is it? And this is a quote from a victim of image exploitation, and I think it really speaks to those misconceptions right off the bat, that this is something that is, maybe a mistake made by the victim, that it's not that harmful, that there aren't these long-ranging effects. But what this speaks to is, hey, this isn't just about naked women. This is really about humiliation, and that pornography is available readily online. But this isn't what these pictures are for. And in fact, the people that are looking at these photos and posting these photos typically aren't looking for just sexual gratification, but they're really looking at a woman being humiliated. And that brings it to a different level when we talk about image exploitation, or in this victim's wording, online rape. So starting with that concept, we'll talk about how image exploitation is the non-consensual creation, possession, or distribution. So again, that broader definition of an image or images of the victim in a nude, semi-nude, engaged in consensual sexual activity, or being sexually assaulted. So how is this image usually sort of seen? Most of the time this is either a photograph, or it's a screenshot, or it's some sort of video recording. And how are they distributed? We're seeing on computers, and that can be email, social media, online posting, cell phones, but there still is the old-fashioned U.S. mail. And in fact, about a year ago, someone brought to my attention a case, I believe it was out of Pennsylvania, don't quote me on that, where somebody was just photocopying flyers and posting them all around the neighborhood where the victim lived. So we also have sharing of in-person videos, so people just taking out their phone and sharing an image with others in person. So a little bit wider of a scope than we might see in the media right now. So how are they distributed? Again, we touched on these, lots of different ways, and really the focus is on technology, and that technology is facilitating this distribution. What types of harm? This isn't just, a passing embarrassment. We're really looking at some very impactful harm, and that can be emotional, physical, but also think about financial harm and social harm, relationships. That's relationships with friends, families, future intimate partners, also professional impact. Again, these days when our prospective employers may be doing Google searches of names and imagine what may come up and how that could impact professions. It's really a unique harm when we talk about violence against women and crimes against women, or really crimes against anyone. And the internet makes it unique. The idea of digital technology makes it unique because it allows these images to remain in the sort of cyber sphere for perpetuity. So this is a perpetual harm. It's an infinite harm, potentially. And it also reaches unknown denizens out there in cyberspace. And in fact, this is an impact statement that was included in the United States Supreme Court case, Carolyn versus United States. And it's an impact statement written by a juvenile victim, now adult victim of child pornography. And why I think it's important to include it here is that she articulates very clearly that not only is she a victim of the abuse that was photographed, but that the real thing that continues with her day in and day out is the feeling that this crime is never really ending, and that whomever she ever has contact with, she looks at with those eyes of, does that person know? Has that person seen? And so the abuse is just over and over and over again in her experience. So what are the challenges? number one is that there's no really comprehensive statute that can address each and every form of image exploitation. As technology evolves and new media platforms emerge, offenders are continually finding new ways that they can exploit and harm their victims. And so that tension between wanting to write a statute that covers all of this and then having to be narrowly tailored enough so that it passes sort of constitutional muster is really going to be difficult. And we see that. So we have these laws that are sort of patchwork laws that maybe together you can fit them together to address the criminal activity. But they're imperfect. And for those of you that are practicing right now, one of the biggest challenges is that they're untested. That means that judges may not be familiar with the statute. Judges don't have precedent or case law to look back at for guidance. And so who they're really going to be looking to for those answers are going to be the prosecutors and the defense attorneys in the room. And so as a prosecutor, it's imperative that you are able to address those questions and lingering concerns that a judge may have and be able to present a strong case that the judge is going to feel comfortable, sometimes, making brand new law. And that's not something easily done. And so those are some of the challenges, and of course, just that ever-changing technology. But we also have sort of the time-old challenges of anyone that has worked with, intimate partner violence or crimes involving women will be very familiar with. And that's that we are faced with some attitudes of victim blaming. And that can come from our investigators that maybe minimize the importance of, having a robust investigation into what they may seem as, some embarrassing tweets, along with our judges, prosecutors, and jurors. And as always, we are challenged to make sure that the narrative is offender-focused, and that's who we are holding responsible for this behavior, not the victim's behavior. That's the traditional way that a defense will work in these cases. The defense is going to say, hey, look at the woman, look what she did. And, I do say woman, and I'll put the caveats out there, and I'm doing my best to sort of be better about that. But our research shows that the number of victims that are women is a lot higher than the number that are men. But that doesn't mean that isn't something we should be open to addressing. So I'll try to do a better job on that. But oftentimes we'll have some victim behavior. We'll have defense attorneys that are focusing on the victim's behavior. And it's our job to sort of turn it around and say, no, this is a betrayal of trust. Look at what the offender did and keep that narrative going. So here's some ideas of, some attitudes that you might hear. Say like, hey, what did she think is going to happen if she takes those photos? Hey, that was really, that's stupid. I guess she kind of got what she deserved for her being not as private as she should have been. Or on the other side, sort of minimizing blame for the offenders by saying, hey, this is just something guys do. And that allows them to escape accountability. So these are, challenges that we have in most of our cases, and they continue on to these. So let's look at some of the variations and examples of image exploitation. Like, what are we talking about? So we're looking at blackmail, sexploitation, sexting, video voyeurism, recordings of sexual assaults, and what the media has termed revenge porn, which a lot of statutes are now calling non-consensual distribution of intimate images, sexual cyber harassment. They may have different words, but that's what we're looking at here. So sexting. This is, sending a provocative text or images via communication device. So usually we're talking about cell phones, we're talking about social media, we're talking about something that may be considered flirtatious behavior. And there was a lot of research done about the prevalence of sexting several years ago when it got some attention about teenagers engaging in this behavior and the fear of parents and others that their teenage daughters and sons that were engaging in this sort of adolescent behavior may be deemed sexual offenders under some child pornography statutes. So there's a lot of attention brought to this. And the research shows that this is really typically very emotionally driven behavior, and there are a lot of other things that we'll go into there. But how common is it? This is really interesting. It taught me a lot about taking a closer look at research that's out there, because the studies really varied widely. So one of the studies said as low as only 1% of teenagers were engaged in this behavior, and then the other was as high as 33. That was sort of the range of, I think we looked at about 5 or 6 when we put this together. That's really the range of methods can be used to explain this wide variance. And things like one of the studies was looking at an age range that went down as young as 11, and other age ranges went as high as 22. So what kind of age group are they incorporating into their research? And also the methodology. So one of the studies was calling landline phone numbers only, and they were receiving permission from parents or guardians prior to speaking to the adolescent in the home. And then the adolescent would get onto the phone and answer these questions. So clearly, perhaps we can assume that those would not be as maybe open, the people responding to those might not be as open as, say, the other study, which was an online study that was open, I think it was via MTV, and it was allowed to, the teenagers were allowed to do it in their privacy with their computers. So there's some common things there. Video voyeurism. This is the idea of an offender secretly photographing or videotaping a victim in a place where the victim has an expectation of privacy. We think about this as like locker rooms or dressing rooms or bathrooms. The statutes vary state to state, which is going to be a theme throughout this presentation, and some of them are being rewritten as we speak because of the changing in technology and the changes that offenders have done in regards to that. So we'll talk a little bit more about that. So here's my caveat, revenge porn. Unfortunately, as the title of our webinar said it, stop calling it revenge porn. Unfortunately, it has gotten the media attention. I think that's what most people out there recognize when you start talking about this non-consensual distribution of images or sharing of images. And in fact, I think Maryland actually, that's the statutory name of their law, but I might not be correct on that. So what is it? It's an image depicting nudity or sexual activity that is consensually taken or shared, but that it is later distributed without the consent or knowledge of the victim. So typically we think about this being done as a way to embarrass, harass, or harm the victim. So as I think the prototypical example would be, two people in a relationship during which they're sharing, sexy photographs. They break up. He gets mad. He posts these photographs either to online bulletin boards or threatens to send them to family or friends. So that's what we're talking about with that. And it can really vary as far as the scope and the intent and the harm. So sometimes it's really targeted, as in they just send a photo to a boss or a parent, or sometimes it's, posting it online for the entire, internet to see. And oftentimes it's accompanied with doxing. And doxing is the term that refers to providing the personal identifying information along with the photograph. So there would be a photograph up there, and then along with the photograph would be the name of the victim, along with sometimes home addresses, Facebook pages, links to Instagram accounts, email accounts, and sometimes inviting the public to then harass that person via that identifying information. Sexploitation, again, this is another variation of image exploitation, and here it's usually when an offender has the photographs, and instead of just posting them, instead of that, they threaten to post the photographs or to share the photographs or images. And then in return for them not doing it, they're demanding money, but oftentimes it's sexual favors. So whether it's an ex-boyfriend that's threatening so that there's remaining an intimate relationship, or sometimes it's it's strangers or people that they've just met online that are then asking for more nude pictures, or sometimes we saw a case that involved a girl that was extorted to the point where she was doing webcam videos for him. Oftentimes, these images will be legally possessed through, a consensual sharing at some point, but oftentimes we'll also see that these are not legally possessed. And in fact, it involves some form of hacking into a phone or online account, and somebody was able to gain access to these photos. Okay, so now that we have an idea of all the different variations of how this may appear, what kind of criminal activity is involved, let's look at some of the existing laws in place as well as emerging laws that we're seeing around the country and figure out how we can fit the activity into the law. So one of the big ways and most successful ways we can do this is through established stalking, cyber stalking, or cyber harassment law that you may have in your state. So the stalking laws typically include language where the prosecutor has to prove that the offender engaged in a course of conduct and that the course of conduct was done with the intent to threaten, cause distress, or harass the victim. So stalking obviously is very broad, and it can include things like, somebody always going by their house, somebody calling their work nonstop, constant text messages and threats, letters in the mail. So a lot of stalking is not going to be image exploitation related. But as you can imagine, a lot of image exploitation is going to be able to fit under this umbrella of pre-existing stalking laws when we see that course of conduct and we can prove the intent to cause some sort of harm. So the course of conduct, again, this is something that's going to be defined jurisdiction by jurisdiction a little bit differently. So since this webinar is for a wide audience, we can't look at all the individual statutes for each state that's there. But I do want to just do a little shout out to AEquitas, which is that we do a similar presentation to this that is state specific and that we can provide the resources for anyone that is looking at, hey, I'm from Nebraska and I'd really like to see if our statute fits this, or what can we do in our state, and that's something that AEquitas will really be very happy to help you with. So back to this, the course of conduct. So it's this repeated behavior. But the challenges are, can we apply this where an offender may send just one image but is sending it to multiple people? Can we argue that that is a course of conduct, that repeated behavior is all the different recipients that this email had? Are we going to have an easier chance if this was sent in 50 distinct emails versus one email with 50 respondents? And can we make the argument either way that this should fit under a definition of course of conduct? Again, now what if it's just one post that's posted online to some sort of bulletin board or social media, and then that photo is viewed by so many people? Can we fit this into our course of conduct? I think it's really going to depend on how narrowly tailored your statute is, if there's any wiggle room, what case law you may have in your state that talks about course of conduct, and things like that. But there is an argument to be made for sure, and not something you should just give up on. Again, intent. Typically, statutes include this element, and sometimes it's to harass, cause distress, or to harm. So again, can you just from the act itself presume this type of intent? Or what's always, difficult for the prosecutor, anytime we have to prove the mental state of another person, how do we prove what's in somebody else's mind? Well, oftentimes that's through circumstantial evidence, and the same thing will happen here. And, I don't think it's going to be that difficult in cases where, hey, offender sends a nude picture of an ex-boyfriend, and they send that nude picture to somebody's boss. What other intent might there be other than to cause some sort of harm? So I don't think this is going to be the major hurdle in anyone's sort of trying to push these cases forward. So really, I think the challenges are going to be that course of conduct, anytime the communication is not going to directly be sent to the victim. Some of the statutes say, hey, this has to be a course of conduct directed at the victim. Okay, what if the emails are sent to family and friends? The email is not sent to the victim. Is there an argument to be made? And I would say yes, that's actually activity that's still directed towards the victim through their family and friends. But you can show the proof of intent. And then really a lot of what the challenges to all these laws are that there are going to be misdemeanor charges. So we're not looking at a lot of time, a lot of teeth. So some of the strategies we'll look at is to try to overcome that. So the argument really is, hey, look at the statutory language, and when we have broader language that allows us to make those arguments, that talking about continual harassment or continuous harassment, perhaps we can talk about that perpetual nature of this harm as a continual harm, therefore it should fit under this. But again, case by case, we're going to have to look at that. Now, what about the First Amendment? So in the news last year, we saw a big case with the Supreme Court, and basically they struck down a conviction where a man had been making threats on Facebook and other social media of really violent language towards his estranged wife. And the case came out sort of with the idea that this was unconstitutional. And a lot of people immediately thought that it meant, hey, it's a First Amendment right to say or do anything online. But I'm here to say keep calm and understand the case law. It's Alona C. United States. We actually have a webinar of the same name available, recorded on AEquitas that talks in depth about the case. But just generally, I'll let you know that the crime that was implicated here is the U.S. federal crime. And it says that whoever transmits in interstate or foreign commerce any communication containing any threat to kidnap any person commits a federal offense. And what the Supreme Court basically said was, hey, this statute is it's flawed. The statute itself is flawed because it doesn't specify any mental element for the threat. So what the trial court had done here is it just sort of it put its own negligence standard. Hey, would a reasonable person realize this would have been considered a threat? And the court said you can't just do that. The statute needs to have a mens rea element, some sort of mental element built into the statute. So it's really an error in the statute, and it doesn't really speak to the idea, I think misconceived idea that, that we have this big First Amendment challenge. So in fact, with just a tweaking of the law, I think this case would have been fine and would have been upheld. So recordings of sexual assaults. I am seeing and hearing about this more and more, both on the news and also from prosecutors that are reaching out to me and wondering what to do with these cases. So overall, we're just seeing everything being recorded, right? And that includes these crimes. And the idea of a sexual assault being recorded and that assault being out there in perpetuity and shared with others is just a compound harm that is being done to these victims. And so how do we deal with that when the victim's assault becomes part of the public domain, right? And what are the consequences for those who film or share this assault? So the prosecutors are tasked with a big legal challenge to try to figure out, hey, can we charge this person with the assault itself? Is something about them being present or perhaps giving words of encouragement or providing the space for which the sexual assault took place or providing privacy for the sexual assault to take place? Are those overt actions that we can charge the otherwise bystander with that is also filming this assault? And I think there's a lot of people out there that are really working very diligently to make those cases. But we can also think about, hey, are there some crimes of image exploitation that we can charge in these cases? what else can we look at to make sure that those are, being appropriately handled with, and that there's some sort of criminal liability for this behavior, if appropriate. So one of the ways to do that is perhaps employing our video voyeurism statutes or our invasion of privacy statutes. So the federal government and every state has a law that protects individual privacy rights. And that's usually in the form of a video voyeurism or an invasion of privacy statute. And it makes it illegal to secretly film or photograph someone that's nude or someone that's engaged in sexual activity. The challenges are that these statutes are written for that sort of prototypical peeping Tom case, that now we have a peeping Tom with a camera case. And so many of them require that the victim be unaware that the recording was taking place or that the recording was done secretly. And you can imagine a situation where sexual assault is happening and the victim is very aware that she's being recorded and that it's being done in sort of a public setting. So we're not talking about a secret camera in a locker room. So what happens there? What if they're aware but they're not consenting to the video? What if the victim is unconscious? So I think this is really a significant gap in exploitation law, and there are some legislators that are taking a hard look at this because it's really a problematic application of these laws. And in fact, you'll see that in Washington State, and I think New York as well just recently changed their statutes. And this was in response to cases where it was secretly recorded, but it wasn't recorded in a place where the victim had an expectation of privacy. So that's usually another piece of these video voyeurism laws. The victim has to have an expectation of privacy. They can't just be in public. Well, what happened was there's these upskirting or down blousing videotapes. Guys are putting small cameras on the bottom of their shoes and following young girls up escalators that are wearing skirts, or filming, women in subways, somehow getting their camera positioned so that they can film a skirt or down someone's blouse. So these statutes have been challenged. Actually, there were convictions in these cases, and then the higher courts had to overturn them, saying, hey, this law is flawed, and this statute doesn't fit because this is done in public, and the victim doesn't have an expectation of privacy on an escalator. Does she have an expectation of privacy under her skirt? Yes, but that's not how the law is written. So we're seeing some changes here, but just really kind of, it emphasizes that ever-changing technology and how people use technology is going to constantly affect our laws that may need to be sort of regularly updated. And we don't really think about laws as, they're laws, they're black and white in the law books. We don't like the idea of having to continually sort of update them, but that might be what's happening with the technology changes. So prosecutors should really adapt their voyeurism laws, their invasion of privacy laws, look at them, do a statutory analysis. Again, AEquitas is happy to help you with that. And then make the arguments that, victims always have an expectation of privacy when engaging in sexual activity, and especially when sexually assaulted, that we're not going too far to say, hey, a victim should have an expectation of privacy when they're being, raped or sexually assaulted. So the argument ultimately is, hey, this is the ultimate invasion of privacy, and it should fit under these laws. So we also want to think about charging co-occurring crimes, really look at what the role of that person is. We talked about other things that person might be doing to encourage or provide assistance to the offenders that are actually committing the sexual assault. So we might think about conspiracy, accomplice liability. There are some states that have a failure to report a crime. I think Texas is one of those. And look at that and see, can we apply that in cases that involve reporting of sexual assault. So theft by extortion or blackmail. Again, state by state, you may have a theft statute that incorporates sort of a blackmail or extortion with it, or you may have a separate standing blackmail statute. And here we have the theft by blackmail might be the offender who unlawfully gained control of the image. So maybe a hacking situation and then threatening to expose them. And the blackmail, doesn't matter how they gained access to the photograph, it's really about the threats, which are implied with the, hey, unless you do X, unless you pay me this, we're going to release these explicit photographs of you. The challenges of those cases are that most of them are graded by some sort of monetary value or thing. So you might have a theft in the first degree when the value is over $20,000. Theft in the second degree when the value is over $1,000. Theft in, a misdemeanor crime if it's under $300. So when we're trying to put a monetary value on these types of cases, we may be really challenged. So you have to have creative arguments about value, and then you also may want to think about, again, stacking those charges, charge multiple counts for each threat so that even if we're looking at a misdemeanor, because we can't prove a monetary value, we're able to at least every time that threat happened add another charge and gain some traction that way. Hacking or trespass. So some of our victims have never shared these images. These are things that they've taken in the privacy of their home and that they've kept for themselves, and somebody gained access to them. Or maybe they shared it with one person, but we've been able to prove that that person is not the source of the distribution. So what is the source of the distribution? Perhaps it is a hacking issue. And so when we're looking at hacking, that opens us up to an entirely other section of possible crimes that were committed that include computer trespass, explicit hacking statutes. And again, that's going to look at what's available in your state. How is that defined by your statute, and how does the legislature deal with those types of computer crimes? And again, we may have, as we look through all of these, you may be thinking about cases, and you may be thinking, we've got a little bit of video voyeurism, we've got a little bit of that, non-consensual distribution of intimate images, and we may have a little bit of hacking as well. And so again, that only benefits us, investigators and prosecutors, when we can charge multiple crimes that really will encompass the entirety of that offender's behavior. So we also have, I don't want to spend a ton of time on this sexting and child pornography, but I do want to just mention this because if you go out there looking for some research, you're going to find a lot on this. And we're talking about crimes of image exploitation where children are involved, and this may violate federal and state child pornography statutes. And the big concern about the typical teenage behavior has been addressed by many jurisdictions. And in fact, I think I have some in here, but many jurisdictions will have separate and distinct statutes addressing sort of juvenile to juvenile sexting or juvenile to juvenile distribution of child pornography. Perhaps those aren't going to have sexual offender registration. A lot of them are immediately diverted into some sort of cyber safety classes that they require the participants to go through. And a lot of times it's also an affirmative defense. So somebody that is charged with this can say, hey, look, I'm a teenager, they're a teenager, this was shared amongst us, this person is not under 12, I never shared it with anyone else, and I didn't engage in any coercive or behavior to gain access to these photos. And so that would be an example of an affirmative defense to sexting that involves that sort of teenager to teenager. Now, sexting between adults, this is itself not illegal, but this is sort of the behavior that oftentimes will lead to other forms of image exploitation. And then we also have the adults that are soliciting these images from minors, and again, that kind of goes into the pile of that child pornography and those types of crimes that you may have existing sexual offense laws between adults and children. So the juveniles that are sexting, this has really been viewed as either sexual abuse or an experimental adolescent phase. So here we go again. The 20 states have these modified statutes, these affirmative defenses that are available when it's juveniles engaging in consensual sexting behavior. So again, Nebraska has this affirmative defense, and Nevada as well, specifically saying that juveniles are not going to be registered under these circumstances. But there are really complicated motives that are involved in minor-to-minor sexting. So I just want to put this as a caveat out there to not dismiss this as something that isn't worth looking at with an eye towards somebody involved in criminal behavior. So I already mentioned that this is emotionally driven behavior. And our research says, that sexting is often recalled with remorse. So people that have engaged in sexting, when looking at it, sort of outside that initial emotionally driven behavior, reflecting upon it are going to say, oh, maybe this wasn't a great idea. So some of the things that they've come up with is, hey, these are, now I'm recognizing there are some negative effects to this behavior, but then also, hey, this was fun and flirtatious, and then also I was pressured to send it. So really conflicting responses to this teens and sexting, and it's not as simple as, hey, this is just, adolescent behavior. A lot of what I'm thinking about is sort of that pressure to send and how that plays into it. So don't assume this is innocuous. Look at the cases, look at this fact to fact. And so this one study reviewed a bunch of cases, reviewed all the cases that were referred to law enforcement that involved, sort of this juvenile sexting. And when they looked at it, 66% of the cases involved some form of criminal behavior. So that's a large percentage of something that might otherwise be seen as innocuous. So what was that criminal behavior? It was either non-consensual distribution, it was maliciousness, or it was abusive behavior that gained access to those photographs. So the potential harm is immediate, permanent, and enduring. So it's worthwhile to take a look at those cases. We must be vigilant. And really, the big difference here is going to be, is that really consensual behavior, or was it coerced behavior? And is this, where does the line of criminality go through? And when we assess the image of potential harm, I think it's important to note that it does make it worth taking another look at these cases. Okay, so moving on to the term we hate, revenge porn. So 34 states, and I looked at this as in like 2 days ago or a day ago to make sure we were up to date. So 34 states and the District of Columbia now have a law that's specifically targeting this type of criminal behavior. Those states that don't have a law, I think almost all of them have pending laws, things that are going through legislation. And within the last couple of weeks, a federal law was proposed after having gone through many revisions. So we'll see what comes of that. But the statutory construction does vary, and there's been a lot of input from professionals in the field about how we can draft the language to be narrowly tailored enough to pass constitutional muster, while at the same time broad enough to encompass all the differing ways that this occurs. So some of them, and so again, look at yours, these are some of the things that I've noticed as themes. One of them is that the statute may only refer to distribution or publishing of images online or via electronic means. Some of it is only when it's posted to the internet. So that's really going to sort of narrow the field of what can be considered criminal behavior under these statutes. Others of them, when they talk about distribution, are going to be much broader and are going to be talking about maybe a mass text to, a lot of people in a social circle that the victim and offender share. Most of them require that the victim be identifiable. And so what does that mean? Does that mean that it has to be a doxing situation where a name is accompanying it? Does it need to be a situation where the face is identifiable in the photograph, or maybe there are other distinguishing marks on the person's body or what they're wearing, or perhaps a background of a room that would make this person identifiable? So that's another thing you've really got to look at. And then what is the mens rea of the offender? What intent must the offender have when having done this? So we have everything from they distributed it and they knew it was, and they didn't have permission, or they did it with the intent to harm, cause, distress, or harassment. So that's going to be a wide range of what the individual statutes are going to look like. And how must the offender know that the victim didn't consent? Is it going to be, unless the victim proactively consented, the offender is going to be found liable? Is the offender going to, is the state going to have to prove that the offender knew or should have known he or she didn't have consent? How is that all going to play out in court? So those are some of the things to look at when you are evaluating your own statute. And again, AEquitas is happy to help you with that. So what does it mean to publish? Is this a website, or is this multiple messages? Is this an online forum? Is this a Facebook post? Identifying the victim, what's the intent, and what's the lack of consent. And can we have a presumption of lack of consent when somebody sends something to their father or something to their boss? So application in California, this is December 2014, so about a year and a half ago. We're looking at the first successful prosecution. In California, this is done under their disorderly conduct law, which is a little bit weird. But it does still stand as good law. But even after that, even after success, California went back to the drawing board and wrote an amendment. And it includes unlawful distribution of selfies shared with the offender. So just to, again, give you the idea of how these statutes are going to have to be tweaked a little bit, I assume. So in this particular case, the original law was the photo had to be taken by somebody else. And of course, we know a lot of this is probably going to be people taking selfies and sharing selfies. So they had to rewrite the law to include that. And we've talked about this sort of tension between being narrowly constructed, but also being broad enough to include, revisions due to changing technology. So here's some general strategies that I wanted to put out there for any of you that are working with cases involving image exploitation. And that's from an investigative standpoint, from a prosecutor standpoint, those of you that may be working with victims of image exploitation and helping the victim navigate through either a criminal or civil justice process. Hopefully this can help. There's some common attributes, not all the time, there's every different version here, but what we'll often see is this is going to be part of an ongoing intimate partner relationship that involves other forms of control, power, and violence. Digital evidence is going to be key. Yes, there's the random case where somebody's still photocopying flyers and putting them on flagpoles, but most of the time we're going to be looking at cases involving digital evidence of some form or another. So does the law enforcement have the capacity and knowledge to kind of conduct the appropriate cyber investigation to get the evidence necessary? Do the prosecutors have enough knowledge to sort of enter this into evidence? The evidence code has been around forever, way before we thought of, screenshotting Snapchat. So how do we use this evidence code with this completely new forms of evidence that these cases will most of the time involve? And then ultimately, that extensive harm brought upon the victim in these cases that the offender has caused. How do we articulate that? How do we get others to understand why this shouldn't be minimized, while this should be taken very seriously, and that this harm is so extensive? So those are some of the attributes. So oftentimes this is going to be part of a pattern of abuse and stalking and involve multiple acts that encompass an offender's total criminal behavior. Those of you that have worked in domestic violence situations know domestic violence cases don't involve, a snapshot of what happened one night when, he hit her. We're really talking about an ongoing relationship that has gone on for days, months, years, most of the time. And so how do we incorporate trying to tell the victim's full story into our criminal cases? So one of the ways to do that is to charge all of the all of the crimes that we can within our statutory limitation. Charge them all. Charge an umbrella stalking charge that kind of incorporates a course of conduct that can last years. And then within that course of conduct, charge all the discrete crimes as well. File your notices for prior bad act evidence. Also, subsequent bad act evidence. We're going to probably have ongoing witness intimidation after something has been brought to the police or the authorities. We may have tampering with evidence, especially when we have this digital evidence. Are they trying to go online and delete things? So charge all those other bad acts under your 404B evidence. Really strive to show that this is the context of the relationship, that there is this power and control dynamic that's going on that involves each and every one of these things, and you can't talk about one without talking about the context of the entire relationship, because all of that provides the proof of the offender's intent. And when you look at the case law of 404B, what kinds of bad acts can be included, you'll see that there's a lot of great case law that talks about offender's intent in the context of the relationship. So this is really key here. And along with that, you want to think about your civil protection orders, just again, to support your victims through this process. Every state has these, again, in different forms, but oftentimes they are now inclusive of this sort of cyber harassment, cyber stalking, intimate partner violence, and courts are recognizing that. So just make sure that when you get these protection orders, you're really looking at some very specific language that should be included. It should be particular to the facts of your case, and it really should be explicit about forms of online communication, use of victims' images. So really, if you're making that argument to the judge, asking them to put in a handwritten protection order language that is particular to your case. Charging decisions. Think about all those domestic violence statutes that you have. Charge each offense. Also, the other thing is you may want to charge, you think about the victim being the person, right? But oftentimes the way that these laws are written, the victim can also be the person that received these images. So if something's being sent to family and friends and new intimate partners, you can charge the same crime listing them as the victim. So some crimes are going to be, ex-girlfriend as the victim, and other ones you can charge having mother as the victim. And that, again, is just going to give you more leverage with how you can charge these cases. As far as the digital evidence, offenders are using this. Great news is that oftentimes they're going to be leaving this trail of breadcrumbs behind them that allow investigators to really get some amazing evidence that can relieve the burden of a victim having to take the stand and it all be about, her relating the story. In addition to her testimony, now you have this really discreet, almost fun digital evidence because the juries love it. The judges are, they're able to see something on paper or in a video. So how do you do this? And this is a whole nother webinar. We've recorded one that's called Following the Digital Breadcrumbs. It's specific to sex trafficking prosecutions, but a lot of the cyber investigative techniques would be helpful for anyone that's doing this work as well. And again, something we can help you with, how to get this evidence in at trial. So the extent of harm. This is going to be a big deal. And how do we do this? How do we make sure that everyone understands why this is important, why we're putting all of our resources and efforts into that? And oftentimes that's going to be in the form of a victim impact statement. Testimony from friends and family that talk about how the victim isn't living as full of a life anymore and that they're afraid to go out in public or whatever it is. Also sometimes testimony from counselors or therapists can be helpful. But again, that's only if a victim is approving that because we've got some confidentiality issues you really want to look at first. So this isn't just a temporary scandal. We're talking about monetary harm, professional harm, harm to relationships, the ability to live that free and complete life, including an online life. I think some people kind of a knee-jerk reaction is, you don't want to see it online, don't go online. Well, that's just not reality of how, a modern person lives their life. If you're afraid of the internet, if you never want to go onto the internet, this is a huge piece of somebody's life that is unable to be lived fully. And so don't underestimate that as well. it's infinite harm, and it's not just to the family, or just not to the victim, it's to the family and everyone that that victim loves and has any impact with. So really we want to say that there are criminal laws that exist and that they provide these avenues for offender accountability. We just need to make sure that we're analyzing them all. We're looking at the whole range of possibilities because the consequences can be really grave here, and it's worth us to do it. I want to thank Elisa D'Amico, who is from the Cyber Civil Rights Legal Project. She provided me with some great insight today on sort of the civil side of things, and also included these resources for us to provide to you. And a lot of these resources are from victim services, including trying to, take down those images. We know a lot of victims, that's the number one concern. So these will be made available to you via our handout that Emily will get to you after as well. And this is the Cyber Civil Rights Legal Project website. There's a form there for victims to be able to reach out and start some communication, and they're doing really great work. So for those of you that are working with victims, and really anyone that's doing this work, including prosecutors and law enforcement, you should be providing this information to the victims, because oftentimes, if there isn't a criminal avenue to go down because of, the statute of limitations has expired, or you just can't find a statute that fits, there's some civil remedies that you should be looking at as well. And there's a real opportunity to have some synergy between the criminal justice system and the civil justice system in this regard. So those are some great resources for you guys. Going forward, I encourage you all to review the statutes that you have, look at the different types of statutes that we talked about today, and apply them to see, okay, how can I really maximize my prosecution or my investigation by charging all of these or multiple charges of the same. And again, AEquitas will help you with that. Always focus on the offender's action. Always look at what the offender did and try to make sure that you're controlling the narrative in that regard. And how is the offender asserting power and control over the victim? How is the offender threatening this victim, harming this victim? And then strive to articulate as best as you can to everyone in the system about how immense and perpetual the nature of this harm really is, and the harm inflicted upon the victims due to image exploitation. So that is my contact information. I welcome anyone and everyone to get in touch with me about specific questions that you may have. I can either refer you to others that have more knowledge than I, or we here at AEquitas are very happy to help you as well. I think there are a couple of seconds left, Emily, if anyone has any questions. Other than that, thank you very much for participating today.
Yeah, thank you, Jane, and thanks everyone for coming on the call today. And for those of you listening on the recording, I will be sending out the handout of the slides like Jane was saying. I'm also going to be sending a bibliography. There was a question earlier if we could send some citations for some of the studies that we had talked about earlier. So I will be sending that in addition to Jane's biography as well. So if you are calling in and you didn't see the visual, please let me know via email if you don't see the email from me. And thank you again for tuning in. A reminder that AEquitas is a 24/7 technical assistance provider. We're available to respond to your questions, your concerns, your training needs as they relate to prosecution and the violence against women. So on behalf of AEquitas, thank you again for participating and have a good day.